rules. And to just take the example of intellectual property versus freedom to copy, you can hardly determine what is the majority right now. Is it the traditional concept of intellectual property that says, for example, music files are protected, belong to the author or to the rights holder? Or is there a majority of people that say, we want to share any music file that exists on the world on peer-to-peer networks with everybody in the world? So it's quite difficult to determine a consensus, even a majority, for the one or the other solution. It's my impression that at the moment the majority clearly favorites the traditional concept, and therefore we have this problem that the people that say we want to have freedom to copy, freedom to share content, even copyright protected content, are forced into being illegal, acting illegal. And this is a conflict that law as such cannot resolve. So the expectation that you may reasonably have towards your legislator or the legal world as such can hardly be satisfied if there isn't a consensus on how we want to deal with intellectual property. Law is an ongoing discussion, and that may be the sort of an answer to the issues that we quickly browse through. Law is not a thing that is static, it's constantly developing. And if you want, for example, in your practice as a journalist, cover this, experience that, my tip would be look behind the current discussions on the political level and go for creative legal scholars. Look what they have to say. Because information and law, those topics, is a very hot issue currently to be discussed. There is, for example, rather behind the scenes, and not always on a political level, there is an extensive discussion on intellectual property. Data protection is another thing, or access to information. So the question, for example, that you also addressed, to which extent shall public sector information, for example, information owned by the administration, owned by universities, to which extent shall public sector information be freely available to the public, even for commercial reuse, is something that is currently really strongly discussed. There is ongoing legislation in this field, initiated by the European Commission, but still, information and law and the relationship between that, the freedom of information, to which extent shall it be restricted by law? To which extent shall the legal framework allow the reuse of information? Shall information as such be protected? And if yes, to which extent? Is a quite hot topic, and it will be a hot topic for the next 10, 15, even 20 years. Because information and the exchange of information, dealing with information, making business with information, and on the other hand, the importance of information for a political system, for a society, for a free society, have to be balanced against each other. So there are commercial interests, there are society interests, and those have to be balanced. So if you want to really experience that law is an ongoing discussion and maybe innovative, look behind the discussions that are led in public. Go and talk to legal experts, not necessarily lawyers like me, but also the legal scholars in the universities, like Mr. Pollock, and I think it's from Cambridge, isn't he? Who takes, for example,
We sorted that one out.
Sorry?
We sorted that one out. It's from Cambridge.
It's from Cambridge. He has a quite fascinating approach on copyright in taking, for example, an economic approach, an economic value, and his statement that copyright should not last longer than 10 years to promote access is based on an economic analysis of the law. So there are quite fascinating discussions even between the areas of law and economics, law and, let's say, even philosophy. What does law mean? What culture there in dealing with information? So as an operational lawyer, I would say if you want to see lots of interesting things, go behind the scenes, go to see what concepts are developed there, because there's a freedom of thinking that's incredible, even going so far that people say we don't need a copyright anymore. So we need to give up this restrictive system, let all information be free, to think about the consequences that may have such a decision. It's quite worth thinking. The next thing, there is no status of the law, meaning law is not fixed forever. There are only shorter or longer periods that a certain legal provision lasts. So law is quite a relative thing. And if the legislator tomorrow decides that copyright shall be completely deleted, the world would be different, of course. It's not quite likely that this happens today or tomorrow, but only thinking that there changes are possible given the corresponding consensus in society, it's worth thinking too. And the last thing, initiatives for changes in law, at least my experience, may appear quite sudden, but they don't come out of nothing, but they're usually prepared behind the scenes. And that's why I said, look at the discussion, the academic discussion, the discussion in the legal communities. It may be quite difficult for a non-lawyer to really go into details, but on the other hand, there are lawyers, there are legal scholars, there are attorneys, and there are judges who are more than willing to guide you through this world, to set out their point of view, and to make you comfortable with this world. And well, if I can wish something, then that you take this chance. It's an area that is important enough and fascinating enough to deal with that. Thanks very much.